discussion. I wanted to raise an issue that I've been studying for some time and increasingly feel more and more strongly about, and I think it may be a difference of opinion. I think Justice Breyer and I have discussed this perhaps in the past, and that's the issue of cameras in the courtroom. Is there any plan in the works to change, to pilot or in any way increase the use of cameras at the Supreme Court?
Yeah, Mr. Muneer tells me that the Judicial Conference is considering a pilot project that I guess they are favorably disposed of.
And that would be a pilot
be in our court.
What's that?
It would not the Judicial Conference does not have to do with our court. It has to do with the lower court.
Well, let me raise specifically the issue of your courtroom, and I'll share my thoughts on that and be interested to hear your own. I would think probably of any courtroom within the system, appellate courts, both the Courts of Appeals and the Supreme Court, would be probably situated for cameras in the sense that you don't have the same kind of jury issues that you might have at the trial court level. You have the ability of the judges to consider whether counsel are playing to the cameras, and I would think particularly at the level of the Supreme Court that counsel would be very circumspect about playing too much to the cameras, given that if that's not the predisposition of the bench, it wouldn't help them in their advocacy. And I think that this is one of the few areas of the public sector that remains free of cameras, and we're still using sketches and audio tapes, which seems anachronistic. And I just think the change is inevitable. But I'd be interested to hear whether you would contemplate a pilot in your own court, or why the dynamic is so much different with an audio tape versus a videotape.
No, the answer is I think I don't know. I know perfectly well what the arguments. I think I know fairly well after a long time the arguments for and against. If you bring courtrooms into the cameras into the oral argument, there's a big plus for the court, for the public. I think they'll see that we do our job seriously. We don't always get everything right, but we take it very seriously. The lawyers are well prepared. The judges are trying to think out problems that are difficult problems. And for the public to see that, I think, would be a plus. So why not do it? The concerns are not, I think, totally the ones you've mentioned, but that's part. The concerns are, if we bring it into our court, we are a symbol. And if it's in our court, it's likely to be in every court in the country, including criminal procedures, where there are separate problems raised, as you know, judges, juries, witnesses, and so forth. A second problem is, will understanding be promoted if you can, because you can only show the oral argument, which is 1% of what goes on. And people relate to what they see much more than what they relate to what's in writing. And we're deciding cases that we have results for 300 million people, and only 6 of them are in front of us. And we have to worry a lot about what our ruling will do to the 299,909,000, etc., that aren't there. And so will there be misunderstanding about that? And the third, which I think is minor, but it's possibly there. It's not that the lawyers and judges or anybody would act up. I don't think they really would. We just had the Canadians in a visit to us, and they have it in their Supreme Court, and it's worked out all right. But there's some concern about we have a group of people in our press room who know how the court works. And when you read what they say, you know it's being written about by someone who knows how the court works. Now, that isn't always so. The cameras don't always have the time. And will there be misperception given? Now, you can take those 3 worries I've listed and say in your own mind, they don't stack up against the plot. Are those of trustees for this institution that served America well. And there is no going back. I think there is no such an experiment on this in the Supreme Court. You have to decide it. And that's why I think what's needed, comfort level that by giving a comfort level, it may come sooner rather than what I tend to agree with you on, inevitably later. Now, how to get that comfort level is a long, complicated matter. I've always said it will involve studies, and serious studies, not just ones promoted by the press. Serious studies of what's happened in different places. And when I say that, everyone goes to sleep, because if you mention the word study, that's a good somnorific. But I think something like that's necessary. That's why I like these pilot programs, even in other courts. I think there are things to be learned, and I think eventually we'll get the comfort level, but I think we're not there yet.
Just if I can engage a little bit on that, because I think you mentioned 3 different points, probably the most substantial being that, people could misunderstand because the case only ostensibly applies litigants in the court, but it affects millions. There's, in my view, far greater chance of misunderstanding if the public isn't able to see. There's far greater, I think, opportunity for people to be suspicious of the outcome or misunderstand the process or misapprehend the process. They don't have the window into the court's workings that would be provided by actually watching. And so your first observation, I think, is the much more compelling one, which is it would be beneficial to the court because people would understand what it does better. It would be beneficial to the public. And I think that clearly trumps any risk of misunderstanding, which is always going to be present, and I think is more present when things are done less visibly than with more visibility. Is that the tapping of the gavel?
Maybe the 9-minute gavel.
Okay. I'll wrap up, Mr. Chairman. Thank you. I knew I should have made the comment about the Red Sox. I also think that the kind of slippery slope point, but in the appellate courts you must do it in the trial courts, isn't necessarily so. And there are different factors that work when you have a jury and when you don't. And finally, the fact that the print media may be very good and very professional, and you have less control with the electronic media. That's true in our profession as well. A lot of what we do is in writing. A lot of what all government bodies do is in writing. And I don't find that a compelling reason not to go forward. At the end of the day, I think you put your finger up and you said, we just have to and I don't think a study is going to give you a comfort level. I think the only thing that's going to give you a comfort level is by taking the plunge. And I also think, Justice, this is just inevitable. And if it is inevitable, we might as well plunge forward. And I appreciate the Chairman's indulgence. Thank you, Mr. Chairman.
Thank you. The gentleman brings up an interesting issue, one that the Chairman, since his days in the State Assembly, has dealt with, court cameras in the court.